I just want to make sure that I have everything that everybody has. I received an order on hearing from December 5th from Miss Winkles. And then I feel like there was
A declaration from my client came a couple of days later.
And then you have a declaration from my client.
And those were I have those dated the 11th, both of them. Is that correct? Well, at least
mine is dated the 11th, along with my proposed order. I think we received Ms. Winkle on December 8th. So I'm assuming it was filed December 8th, maybe.
Mine might have been filed on the 7th or 8th. Well, let me see. Hold on. I thought they should have been done before that.
I have a supplemental declaration regarding the presentation from Miss White and it is dated 12/8 in Odyssey. And then it looks like there's a motion for reconsideration, which is I would have technically not before me today, but that was filed on the 11th along with the objection to the proposed orders. And then there was a reply declaration
on
the 11th from Miss McLean's office.
That's correct.
And then that's it. Is that?
Yeah.
Okay. All right.
So yeah, my clients at our proposed orders were filed on December 6th, and that was at 136, CP 136, and then on the 11th, or not on the 11th, I'm sorry, on the 8th, and I think that's where Miss McLean was getting that's when my client filed her declaration. So we had two separate dates. We had the 6th and the 8th, and then Miss McLean got all four of hers on the same day, on the 11th.
Okay.
And you should have a proposed order from me that's a cleanup, assuming you adopt all of my objections.
I don't know that I do.
You should have one that says order on hearing December 5 with my name in the footer. And I signed it I'm assuming the 11th, 10th or the 11th. Oh, I may not have signed it. Oh, wait.
I only have an order on December 5th, 2023 hearing from Miss Winkles. And Madam Clerk, you don't have any orders in the courtroom with you that didn't get back, do you?
No, I do.
All right.
Okay.
Is that Cheryl in the courtroom?
Yes.
All right. Okay. Thank you, Cheryl.
Do you have the Friday presentation docket this week?
Mm-hmm.
Would that be better, Miss McLean?
No.
So that you can get okay. I just wanted to see if you wanted to get your proposal.
No, because I'm in the air on Friday.
Ah, okay.
Okay. So then I guess we'll just work off your objections. Is that
okay? Sure. And then if you decide that you're going to adopt them, I've got an order that is clean that I can ship over.
Okay. And I will work off the order right now just in case you don't adopt them all. And I can send it out via email to everybody.
So basically, throughout, I changed the identification or the identifiers of Mr. to Eric. I changed father to Eric. I changed mother and Mrs. to Rita. I changed child to Benjamin, just so that we're clear as far as who all we're talking about. And then specifically as to finding number 5, the two issues as it related to the tax return were not only the Social Security number, but also the job type that also was on that tax return.
Hold on, Miss McLean.
So
Miss Winkles, any objection to that first change?
The first one, the changing it to, from Mr. to the name, I don't mind. I don't care either way, to be honest with you. So that works out perfectly. The one about his job, how would you suggest throwing that in there? Or how did you?
Well, if you go back to the tax return that she filed on page 2, it identified him as a biologist. Well, I think wildlife biologist. And the question is whether or not having his job identification and his Social Security number in the tax return, whether or not that was potentially a basis for the IRS to suggest that she was claiming.
Yeah, and I have no problem. I mean, I copied this almost verbatim from the transcripts, but it doesn't matter to me as long as I know where to insert it. So social security number, inclusion of a social security number and job or in career or
Job type.
and job type. Okay.
But I'll adopt those first two.
As it relates to finding number 6, just clarifying that it's parent-directed phone calls only during the winter and summer breaks.
And
and then also that all other video and telephonic contact shall be child-directed, with the custodial parent facilitating the phone calls requested by the child to the other parent. And I believe that that's consistent with your ruling, and also is outlined in the clerk's minutes as it relates to page, this is on page 2, the 6th paragraph.
So I have in my notes that parenting and plan to allow for video chat between non-custodial parent every 3 days minimum during extended summer and holiday breaks. And then if the child requests additional video visits, they should be granted.
If Your Honor will look at number 4 on the orders, that's where it talks about both parents are instructed to facilitate these calls. There shall be no interference. I had that in the, I kind of split up the findings in the
number 4.
Yeah, if you look at
order
on the order part of it.
Oh, on the order part. Well, that would be those are findings.
Well, they're not findings because they're ordering no interference and facilitation. I mean, it's an order. It's not, I'm finding that, they're arguing. No interference.
So I feel that number 6 in the findings portion. So I guess the findings number 6 on page 2. They all say page 3, but it's page 2. Does reflect. So my notes say that every 3 days minimum during extended summer and holiday breaks. And then if the child wants more, that they should try to accommodate. So
you just indicated extended because we had talked specifically about which one of those holidays were extended, and we talked specifically about winter break. But if that's what your order is, then I would ask that you add in the word extended before holidays, because I mean, technically under the temporary order, and I apologize, I didn't grab all of my files. Under the holidays, there's like I think there's the typical 3-day weekends, if I recall correctly. I don't anticipate that the court would consider that an extended holiday. Let me pull that
anything that's beyond, I mean, because the normal schedule now is every 3 to 4 days there's an exchange of the child. So anything beyond that time frame. So so if the child is gone for
holidays and summer breaks longer than 3 days.
Well, I mean, the only one that applies to, quite frankly, is summer. I guess technically, Easter's a weekend. It's a day visit.
The spring break. Oh, the spring break visitation's longer, isn't it?
Spring break is 5 days.
Yeah.
but not, I mean,
go ahead.
And again, I just object because I literally took the transcripts and just put them in. So these are, I believe these reflect your orders.
And I'm talking about practical application.
And I understand that. So what an extended break wasn't defined. I think any summer or holiday breaks, and my notes say extended summer and holiday breaks, non-custodian parent every 3 days minimum. So let's set any visitation or extended summer and holiday breaks would be longer than 5 days.
Longer than 5 days. Okay. Got it.
So you can assume that you'd get at least one contact on a 5-day visit with the child.
And that's parent directed.
Yes, and then if there's any additional, if the child is requesting additional and that can be accommodated, it should be.
Okay, so
Um,
the 5-day one is parent directed, right? Is that what you said?
Yes,
And then,
so that, and
okay,
that's for the extended,
okay,
so that's basically defining what extended summer or holiday breaks is, 5 days
okay.
and up.
Okay, and then if
So
the
then
child
is
wants
court-
more, they should accommodate.
So is the court adopting then my language that says all other video and telephonic contact shall be child directed with the custodial parent facilitating the phone calls requested by the child to the other parent?
I think that that sounds appropriate, yes.
Okay. So then on number 7,
Wait, Ms. McLean, where was that real quick so I can pull it across?
Number 6 in her objections.
Okay, I've got it,
page
thank you.
2. Number 7.
Actually, I apologize. That's number 6 in her proposed order, which is in Odyssey. It's just not before me in real life.
Okay.
Sorry.
No, that's okay.
So then, as I understood the ruling and went back through and looked at the clerk's minutes, I was under the understanding that the prerequisite to obtaining the passport was the filing of the bond, or alternatively, the $10,000 deposit. And so, I guess that's maybe sort of the first rub, is whether or not that was the court's intention with that prerequisite. And then once she complies with that, then he's to obtain. The court did not make specific findings as it relates to evidence about the mother and whatnot. Your inquiry was as to Brazil being a signer on the Hague Treaty Convention. Oop, and it looks like I spelled Hague wrong. I apologize. And then again, the requirement for her to do these 2 things as the precursors. So that's basically the nature of my objections to paragraph 7.
And Your Honor, if I may, I actually took your findings word for word on that when you specifically stated that she, that she had, what did you state? That no substantial evidence suggesting she posed a risk of abducting the child. You noted her long-term residence in the U.S., her ties to the community, and her lack of any history indicating a likelihood to violate court orders. And you also talked about the maternal family in Brazil. I took your words exactly word for word in that section. I think that is reasonable because that is exactly what we were talking about during that hearing, is that she has never done anything. And I spoke to the court about that in order to have findings, 191 findings, there has to be substantial risk. And it can't just be based on a fear. It has to be based on something grounded. It wasn't just the Hague Convention. In fact, we touched very little on that part. It was more to do with the fact of mother herself not having any of the risk factors that would make it likely for her to be somebody who abducts. So I'd ask that my language stay because that was your language.
Again, neither the clerk nor I captured those specific findings. My notes did not capture those specific findings. You had talked about her national origin of the mother being in Brazil. You talked about your belief that she has every intention to come back, which is not one of the factors. We talked about the Hague Convention.
I could actually tell you the minute and second of where it was in the ruling. I don't know if you have access to those audio files.
I haven't ordered one. Did you order one?
Yeah, well, no, I record them because I'm dyslexic, so I have to record. I don't record the conversation. I record the I have a transcriptionist type them out in here, and then we do a syncing back. I have the staff. We use like really bad AI, I guess, Otter, and it like can listen to the hearing and it types it out, and then one of the legal assistants will go and fix it. But yeah, we have I believe we do have the CD now, because that's how they fix it back. I
All
did
right,
not put anything on TikTok.
I wish I had a better memory of exactly what I said all the time, but I do not. I am going to I've reviewed paragraph number 7. I think I take Miss Winkle's word that this is the words that came out of my mouth, and I know Miss McLean disagrees. The only so I'm gonna adopt this here because I agree with it. I don't think that there's substantial evidence showing that she's a risk. She has been a long-term resident of the United States. Mr. White was aware of her international ties when they began a relationship and got married and chose to have a child. She does not have any history that would indicate that she is going to violate orders. I think also we should note, but I would ask that you note in section 7 that the guardian ad litem weighed in and based on her information that she felt it was appropriate to allow mother to travel with the child as well.
And then the question is about the precursor in regards to the bond or the $10,000.
That we didn't talk about that, the order of things. So
yeah. And that was the thing. So just so you guys are aware, I did again look into a travel bond is for travel agents. So there is, I finally found one though. It's called, I can't even pronounce it. Nay something, it's Latin, a bond. There is one. There is. It's in a different state. I have found one place that may do it here. We have a call into them. I'm not sure if you found any, Ms. McLean.
Nay exit bonds do exist in the state of Washington. There is nobody in the nation that will, from at least our subsequent research, that will issue one for Brazil because they are non-compliant with the Hague. While they are a signer, they have been non-compliant with the Hague Convention Treaty, and they do not interpret the language of the Hague in the way that it's intended to be. There are extended delays for them in trying to find or locate children. There are extended delays based on an interpretation of a 1-year rule that they take longer when they do comply. But typically the judiciary there has not complied. And so that was part of the motion for reconsideration, is the fact that they're one of 8 countries that are non-compliant, but they have historically, apparently and consistently been non-compliant. And if I recall correctly, I think the study from 2023 indicated that there's still, I think, 18 cases that are outstanding of children that have either not been located or not returned despite requests. Currently,
and like I said, I have a call into one, so I should know about that.
Okay, well, my recollection is my first, based on the notes and the minutes that I reviewed, that the travel bond, which is, and I know that we may have gotten confused with a travel agency bond, but the travel bond was the court's preference, and I noted that would because there was still some research and calls out to a location, that would be the court's preference. If that didn't exist, then the secondary would be essentially filing a bond with the court.
And I guess the other question is, now Ms. McLean has it as a precondition to obtaining the passport. We have it as a precondition to getting the passport, as in she can apply for the passport now through the US government, but it's going to take weeks and weeks to get it. And in that time, she can go and put the bond in. It just means she doesn't get the passport in hand until she has that, because there's no worry that she's going to steal it if it's in my safe. She's requesting now that it be in my safe or Miss McLean's safe. There's no question she's going to get it. So it shouldn't be before she's able to apply, because the application process is long. And on top of that, they have to get a visa to go to Brazil because he's a US citizen, the child.
So here, my recollection was that we determined that the passport would go to dad.
Yes.
And then, dad, if dad wants to give that to Miss McLean for safekeeping. So I know you don't want it, but I think it's probably appropriate for someone other than him to have it, because I'm sure he doesn't want to be accused of not turning it over if it's required at any point. You know what I mean? It's probably just better. And my understanding was, or my recollection, excuse me, was that that's child's primary address. That was what would be utilized. So frankly, I am concerned about the bond issue and the information that Ms. McLean has provided. That's obviously an motion to reconsider that I will address, and Ms. Winkles will have an opportunity to respond to as well.
Yeah.
But I think there's enough layers of safety that we don't have to wait for the bond to be filed before the process can start. So I'm going to say that Ms. White can start the process. Mr. White should aid in that in whatever manner is necessary, knowing that any passport is coming to him. So it's not like that passport's going to go to Miss White and then off she goes. So I think that process can start. The visa application can start, but clearly there's still this bond issue that's being looked into and addressed.
So here's the other potential wrinkle. So my client, and you'll see this in his reply documentation, the parties had pre-agreed that she was going to have, I think, December 10th to December 25th. My client's going to have from December 25th to January 7th for the Christmas break. My client was actually supposed to fly out, I think, yesterday. Right now, my understanding is that he's planning on flying out on his vacation time that he's taken off, that's been planned since July. He's supposed to fly out tomorrow, from what I understood. And now there's been an appointment for this passport on the 14th, which is after he's supposed to fly out.
The appointment's for tomorrow is what I was just told. So the appointment is for tomorrow.
Okay. Do we know what time? Because if my guy's flying out tomorrow.
He doesn't need to be there as long as he signs the forms, though. Is that right? Gets them notarized, the application, because you can mail in those applications as well. He can fill out the notarized form of release. And yeah, you can, there's 2 sections, and as long as it's notarized, you can fill it out and anybody can turn it in. But it has to be a notarized copy. I'm not sure if he has a copy.
Well, forward me what he needs to sign today. I'll get him in here this afternoon. We've got about an hour and 15 minutes.
All right. If he can do that, that would be amazing. I would appreciate it, but I do not expect him to further delay any travel plans that are 6 months out to accommodate this.
How long will he be gone? I'm just concerned because of the visa time and the passport timetable.
If we don't get this done today before tomorrow, then what will happen is that he's back to pick up Benjamin on the 25th.
Oh, okay.
So it would have to occur after that, the
okay.
26th, 27th. Although I know that he and his 2 older children and Benjamin also have plans during the Christmas holiday.
She said he can download the form and sign it. Would he be willing to do that?
Well, we can communicate as soon as we're done here.
Okay. Well, unfortunately,
I just need to make sure that I know what the appropriate form is.
Okay.
So, okay. So is the court then, adopting the language as it relates to the 10th. So I had in there as far as under findings, and I had added this in at 7, that she shall obtain a travel bond of $100,000 or if unavailable, deposit 10,000 with the, and technically that should say 10,000 cash, with the Cowlitz County Superior Court clerk, to be awarded to Eric if she fails to comply.
And I have a problem with the way that's worded. It fails to fully comply with court orders. I think that's too wishy-washy. If she, I mean, that the bond is there for if she kidnaps the child, if she keeps the child too long, if she stays in Brazil longer than she's allowed to by the court. I just don't like the way it's worded because it sounds like quite a draconian thing for something that could be as simple as, you know, I don't know, she didn't facilitate the call, something of that nature. So I'd ask that it be something more specific, as in if she attempts to take or extend Benjamin's time outside the United States.
And I'm sorry, Ms. McLean, you're referring to the underlined portion on findings on this page 2 of your objection?
Under 7, lines 21 through 26.
Okay. Okay, so this is, I'm gonna adopt Ms. McLean's language, but I'm gonna change it a little bit. So however, Rita White shall obtain a travel bond of $100,000 or if unavailable, deposit $10,000 with the Cowlitz County Superior Court clerk of the court to be awarded to Eric White if Rita White fails to fully comply with the court orders by returning to the United States at the prearranged time.
And can we add in the word cash after $10,000?
Yes.
United States at the pre-assigned time?
Yes.
And
I guess if there's a flight delay, Miss White isn't gonna, you know, if there's an airline issue, and I'm assuming Mr. White wouldn't. This is not because there's a misconnection or a flight issue. This is
because she's kidnapping the child.
Yeah. And then moving into the order, part 1.
Asking to add that it was denied in part and reserved as outlined below.
Ms. Winkles, any problem with that?
No, not with that.
All right.
Number 2, asking to clarify that he can claim the child on his 2022 tax return as a tax dependent.
I have no problem with that.
And then also reserving the, I guess she does reserve. So on 20, I'm sorry, the last sentence at the top of, I think that is a legitimate page 3. The court reserves on 2023 taxes allocation of the child as a tax dependent.
Sure. If you want to add that, a few extra words in there, Ms. Winkles.
Yeah.
All right.
Change the at number 4, change the language to reference the parent directed calls. And now that you've indicated for 5 or longer than 5 days, otherwise child directed calls.
Yeah, I'll just cut and paste from the findings in there as well.
6 just clarifies the identities by name. Number 9, again, well,
can I sorry to interrupt you. I'm gonna under 6, the I'd also I think at this point, understanding that there's a motion to reconsider, also like as an added layer that not only the time frame of the travel, exactly, you know, where she intends to be, an address of the location that she's staying, if she's in a hotel, which hotel she's at, if she's staying with family, an address or contact information for those individuals. I think I would want all that information if anybody I knew was traveling internationally, let alone a small child. So I think she needs to be pretty transparent about who and where, and have Mr. White have that information available to him if there's any kind of emergency.
Okay,
If
and she
you
does
could-
plan on doing the 3-day phone calls as well, just like,
Perfect.
because it's an extended trip.
Yes, so that would apply here, but if you could just add in that, contact information and location information where she's staying while she's traveling.
Absolutely.
Sorry, Ms. McLean, number
No, that's
9.
fine. 9. Yes. And so I had asked for ranking of priorities as far as bond versus money. And then strike the language about the bond being tied to employment income. Typically, these types of bonds are collateralized with real property or other tangible assets of the individual, and not with income. So I don't want to limit, and that isn't language that the court ordered.
I think that was
Right.
me Googling it and finding a
Yeah.
travel agent
And
bond.
Yeah, no.
And that's
So
why they do it tied to income, because it's the travel agent for their travel agency.
So are you in agreement with that, Ms. Winkles?
Yeah, I
Okay.
couldn't figure out, I
Well-
finally figured out what was going on, but I was a little bit, I couldn't figure out
All
because she
right.
doesn't make any money either, so.
All right, so if you would adopt that request from Ms. McLean in section 9.
10, 11, and 12 are just clarifying identities. And then on 13, I'm asking that you strike at this time, and clarify that the court denied Rita White's request for attorney's fees.
That's fine. You can do that if you want to make that change.
And then I just am asking that reservation language be added for such other individuals as court may deem just inappropriate. Or I'm sorry, yeah.
You cut out a
Not
bit
present
there.
Cut out, yeah.
Sorry, let me put in my other. Okay. Just asking to add the reservation language that in all of the respects not inconsistent with this order, the prior orders shall remain in full force and effect, since this is a supplementation to those orders.
I have no objection to that.
All right.
And I can have that to everybody by tomorrow afternoon. If that's all right.
Ms. McLean, if it looks good and you can work out the kinks and
Sure.
send it to me, I'll happily sign it ex parte and get it filed.
Okay,
All right.
thank you.
All
Thank
right,
you.
and then I don't think we have any other hearings at this point. And the reconsideration will take that its own path there. I will get rid of this proposed order.
And I was actually going to
Yeah.
ask you, both of you, if you'd like a copy of that really poorly AI transcript, but it sounds like if we're doing reconsideration that the transcript goes in anyway, I'd assume. So I didn't know if either one of you wanted it, but nope. All right.
I have access to FTR, so I can
Oh, okay.
listen to it again or watch it again. So
Okay.
if Miss McLean wants it and you want to share it, then by all means, but the court doesn't need it. So
Okay.
Thank you.
all right,
right,
thank
thank
you.
you,
Good
Donna.
luck. And we can go off the record.